SJC-12625 in the matter of a juvenile.
Oh,
Sorry.
I had emailed that 12660 will go first because we're splitting our time, if that is okay.
That's fine.
Okay,
Counsel,
great.
yeah, 1 second, yep. SJC-12625 in the matter of a juvenile, and SJC-12660 in the matter of a juvenile.
Good morning. May it please the court, Melissa Celli for the juvenile in docket number 12660. With me is the juvenile's trial attorney, Katherine Perry-Lorentz. Attorney Jellison and I are splitting our time on the issue of the retroactivity of the new definition of delinquent child that was present in the Act relative to criminal justice reform. I will be discussing the argument that General Law, Chapter 4, Section 6 for interpretation of statutes does not apply to this case. And obviously, I will also be available to answer any questions specific to my juvenile who was charged with the first offense misdemeanor provision. Attorney Jellison will be discussing.
Before you get warmed up, with regard to Section 72, is it your view that the effective date is the date pursuant to the emergency provision of April 13th or the 90 days of July 12th?
I think it has to be the 90 days. I think it has to be July 12th.
So you agree that July 12th, 18 is the operative date?
I think that is the date in question here today. However, that is not dispositive of the issue of whether, once effective, the statute should apply to offenses that occurred prior to that date.
I get that. Okay.
Can I ask, why would they make this provision effective 90 days later than other parts of the bill if they really wanted to make it retroactive?
I think there are a couple of things with regard to that point. First, being the practicality of legislative, the legislative system, which is to say that, we don't know. I don't know why they might have included that. Perhaps it was rolled in with other provisions.
I mean, it's just, when they do that, they usually do it because they're worried about the mechanics of things. And so they delay implementation because they know that, but if your view is right, it would seem like they would certainly not go 90 days. They would at least not carve this provision out. That's what I find really mystifying.
I think one possibility is that they realized that that there would be some cases already in the system that would be impacted, and the 90 days gives the cases that are previously existing in the system time to work themselves out prior to the implementation.
But in your view, though, that those people aren't covered, right? We're immediately applying this retroactively, so none of those people are subject to being delinquents, right?
So I would say in the very closing paragraphs of Commonwealth v. Bradley, the court laid out the exact test for retroactivity that I think should be applicable here, which is cases that are pending on the effective date. So once a case had been adjudicated, then that would be no longer pending, and so the case would not be retroactive. The statute would not be retroactive to those prior cases. The 90-day time frame gives the court some time to dispose of cases that are already in the works, so that they can be disposed of prior to the effective date. But then once the effective date comes into play, then cases that are still pending on that day need to be dealt with under the new legislation. And I think that this court has a wide array of jurisprudence on the issue of retroactivity. Not necessarily clear that all of them are congruent, internally consistent. So there
Straighten that out for me.
well, there's a line of cases that is still good law at the moment, which says that when a court has legislatively conferred jurisdiction and that jurisdiction is removed, it is effective immediately. Then there are another line of cases that don't even reference those cases, but say that the presumption is for prospective application. However, I think that what's happened in more recent years, those earlier cases that I was talking about, those are some older cases. It seems like in recent years, the court has moved toward a substantive versus procedural type of analysis. And by and large, the court has come down on the side of procedure when it comes to jurisdiction. Most of the time, though I cannot say all of the time, when a statute governs jurisdiction, it is deemed to be procedural and thus retroactive. Again, that's not always the case. For instance, I'm sure the Commonwealth will discuss Watts, but I would remind the court that Watts was decided under Mass General Law, Chapter 4, Section 6. So that, I would say, falls under a different category that my sister will be discussing.
Okay, I thought you were going to argue why 4 Section 6 does not apply.
Exactly. So
Okay.
so those I set aside. So Watts is the notable exception about jurisdiction applying retroactively. In Watts, they apply it prospectively. But again, that was under General Law, Chapter 4, Section 6. So I would set that aside for now. Attorney Jellison will discuss that later. Two things are very clear from the court's jurisprudence, and the first is that the juvenile justice system is not a penal institution. In juvenile justice, we talk about aid, encouragement, guidance. We talk about best interests of the children. We talk about rehabilitation. Compare that with the adult system, where we're talking about deterrence, retribution, incapacitation. These are words to describe the outcomes in the different systems. So we have the fact that the juvenile justice system is not a penal institution. And next, when it comes to the jurisdictional question, General Law Chapter 4, Chapter 4, Section 6, second, only applies to strictly penal statutes, as this court has repeated over and over again. Here, because
Well, it applies to penal statutes, whether strictly is your sort of
well, strictly that's language directly out of Nassar v. Commonwealth, so I didn't make it up out of whole cloth.
But I mean, it seems is after July 12th, 2018, the court would have to, in the pending cases, make a determination of whether an 11-year-old is a delinquent child. That's the ultimate adjudication. That's the conviction in a juvenile proceeding. Mm-hmm. But after July 12th, the court can't make the finding of a delinquent child because a delinquent child is defined as being somebody who's 12 and over.
That's exactly right, Your Honor. And those facts specifically pertain to Attorney Jellison's case, but the same holds true for the first offense misdemeanors in my case. In my case, the child was charged with a first offense misdemeanor, an offense that we all agree, though the trial court did not necessarily latch on to this part of the provision. I think the Commonwealth and I both agree on this point that the offenses that my juvenile were charged with are qualifying offenses. So on the effective date, as of that date, the court no longer had the ability to adjudicate the child a delinquent child.
So Justice Ireland applied Chapter 4, Section 6 in Watts, a case involving juvenile jurisdiction. So why is this different, and why should we not apply 4 Section 6 in this juvenile jurisdiction case?
This is the first time that the jurisdiction only of the juvenile court has been affected. In Watts, in Nassar, in all of the previous case law, you're talking about changes between the intersection of the juvenile system and the criminal system. So the criminal system is undoubtedly penal. There's no question that things in the criminal justice system are penal. So when Watts changed the age of the juveniles that would be seen in the juvenile court, that necessarily also impacted the jurisdiction of the criminal courts. So there you were talking about a change. And accordingly in Watts, the court goes through a lengthy discussion of how this changed so many various parts of the criminal justice and the juvenile justice systems. Here, because we're not dealing with the upper age limit, we're dealing with the lower age limit and children who would otherwise not be in the, with the first offense misdemeanor, children who would not otherwise be in the adult court system. The adult court system remains totally unchanged in this case. It's just untouched. Here, we're talking only about changes to the juvenile court system, which is a huge difference from Watts.
Right.
Thank you so much.
Ms. Jellison.
Good morning, Chief Justice Gants, Associate Justices, and may it please the court. I represent the child in case 12625, the 11-year-old child. And as Attorney Celli said, I will be discussing if General Law, Chapter 4, Section 6 does apply, and specifically whether the exceptions in the preamble to General Law, Chapter 4, Section 6 apply to this case. I would like to start with the repugnancy exception. This court in Bradley stated that the repugnancy exception applies where it would be contrary to the purpose of the statute to delay the accomplishment of that purpose. Put another way, where prospective application would be inconsistent with the purpose of the statute at issue. Here, the purpose of the statute at issue was to end juvenile delinquency prosecutions of children whose conduct occurred before the age of 12. And that is children ages 7 through 11, children in 1st through 6th grade. And it did this because adjudication in the juvenile justice system, in that process, harms children rather than rehabilitates them. And specifically, it makes it more likely that they will recidivate in the future. And I want to hit 3 points with regard to the repugnancy exception. Number 1 is this harm. At Appendix 261 of my or Addendum 261 of my brief, this harm is pretty clear. 70% of the children involved in the juvenile justice system have multiple issues: trauma, mental health, substance abuse issues. Being criminalized at this age, even though this isn't a criminal system, it feels like it to children, is harmful to them. And if we continue this harm, it is strictly inconsistent with the legislature's purpose of ending that harm. Now, in Bradley, the court said that it isn't enough for there just to be some unfairness to a particular defendant. They were looking for a bigger impact. And in this case, we have that bigger impact. The harm to the juvenile is not just individual to that juvenile. This is a harm to the community. This is a harm to a juvenile that causes later recidivism, and therefore a risk to public safety.
They're also victims, though, right? We have your client's accused of raping another child, right?
Yes.
So we've got, the community, we've got two sides to the community, right? We've got the victims and the juveniles, right? And the legislature doesn't make this immediate. They could have made this provision immediately effective, right? This is so important, we have to stop, delinquency proceedings against 7, 11, whatever the time difference is. They could have said that right up front. And they could have also included this in the provisions that went immediately into effect, but instead, they even put a 90-day, tail on this provision. It just seems odd to say that they wanted to end all delinquency proceedings against kids this age.
I've had a two-part answer to your question. One, to address the point that you made about victims, and one, to address the point of the 90-day delay. So to address the point about victims, I think we really have to look to the legislative purpose here, and the legislators are the ones that can weigh what's important here. And what they did was to say that the harm to the juvenile delinquents in this case and removing that harm was so important that they were going to remove that area of redress for victims, having someone go through the juvenile delinquency procedures. Not that there aren't services now available to both victims and delinquent children in the community that they could access. So then moving on to the 90-day delay. I don't believe that the 90-day delay matters as much to the repugnancy exception, and this is specifically because this court in Bradley used two different analyses.
Bradley's the mandatory minimum one?
No, Bradley is not the mandatory minimum one. Bradley is the school zone one. Galvin is the mandatory minimum one.
The language, the 90-day language would be more the inconsistency exception.
Yes.
As opposed to the repugnancy exception.
I very much agree. The manifest intent, or the manifest intent exception
Right, I think that's
incorporates an analysis of the language.
That's a tough one for you, the inconsistency one. The repugnancy, not so much, but, and that's, I think, probably why you started with the repugnancy, right?
That's why I started with the repugnancy, and I think I'll finish the repugnancy, but I would like to address your question as to whether or not I lose on the inconsistency, because I don't think that I do.
Okay.
So with regard to the repugnancy, I just wanted to hit that there's the broad community benefit. And I would be remiss if I didn't say that this legislation had a thread of addressing the disparate impact on communities of color, and the juvenile justice system is affected by that too. Juveniles of color are more likely to be involved in the juvenile justice system and other vulnerable juveniles. And if you look to the debate specifically about decriminalizing disturbing a school assembly, Senator Sear and Senator Jellison specifically addressed this, and they made that connection between that there was a disparate impact of the juvenile justice system. So with regard to the repugnancy exception, harm to children, harm to the community, and a disparate impact on children of color. Now I would like to turn to the manifest intent exception and address your question. So with the manifest intent exception, we have to look to the language of the act, absolutely. But and I think you're referring to section 232, which delays this 90 days.
Right, and then there's also other provisions in the act that make it prospective specifically in the Criminal Justice Act, correct?
Yes, so there is one
They're not-
provision.
And it's excluded from this one and included in the other ones.
Well, so the provision that addresses a temporal application in the act is section 237, and that applies certain sections prospectively. So,
Yeah, but what sections were those, by the way? Do you remember what sections those were? I had a tough time navigating through the
yeah,
statute.
so section 232 sets the effective date 90 days after.
Right.
Section 237 applies only certain sections
Yeah,
prospectively.
it's the certain sections I wasn't able to.
Yeah, so,
What types of things were prospective? Do you have that information?
yeah, I believe it was mandatory minimums, and I think it was a lot of it was the fentanyl trafficking and the mandatory minimums.
Okay.
And there may be a couple more. I want to say that there were approximately 10 statutes that were applied prospectively by the legislature in section 237.
And you were going to tell me why you still went under
Yes,
intent?
so in section 230, so section 237 is important because of section 72, the redefinition of delinquent child was not included in it. So where the legislature omitted section 72 from section 237, that can be seen as an intent to apply the statute retroactively rather than prospectively, which it was doing explicitly with regard to several sections. And then I would point, as to the section that delays the effective date of this act, I would point the court to Bradley. And in Bradley, the defendant made the argument that because there was an emergency preamble, it was the legislature's intent to apply that retroactively. And what the court said in Bradley was that no, that demonstrated only, and that's a quote, demonstrated only that the legislature intended the act to go into effect on that date. And I would say here that section 232 demonstrates only that the legislature intended for this to go into effect on July 12, 2018, and that we should apply this retroactively to cases that were pending on that date. If there are no further questions, my time is up. I rest on my brief.
Okay,
Thank you.
thank you. Ms. Sullivan.
Good morning. May it please the court, Jane Sullivan on behalf of the Commonwealth in the Worcester case, the juvenile charged with a first offense misdemeanors. The motion judges correctly denied the motions to dismiss in both of these cases. The amendment at issue here, decriminalizing certain first offense misdemeanors and completely decriminalizing any crimes for children under 12 is clearly penal and substantive in nature, such that the rules of statutory construction prevent retroactive application.
Let's go forward. Let's assume this case proceeds. What's the adjudication going to be? Let's assume the Commonwealth prevails.
Right, what would the adjudication be? Well, perhaps in the more serious.
The adjudication would be that he's a delinquent child, right?
Yes, perhaps. It doesn't necessarily have to be. I mean, I think the
Okay, well,
juvenile
let's-
court
let's-
has a
let's-
broad
let's
discretion,
assume-
but
right, of
worst
course.
case scenario.
But let's assume the court determines that that's what should happen, but the problem is that after the effective date, it's not within the definition of a delinquent child. So how can you declare someone to be a delinquent child when the statute says that as of this date, a person under 12 is excluded from the definition of a delinquent child?
Because that's not the triggering date. The triggering date under Chapter 4, Section 6, second, is the date on which the offense was committed. Both offenses in these two cases were committed well before the effective date, July 12, 2018. In Worcester, it was June 13th. In Hamden, it was November 2017. The complaints issued well before the effective date of the amendment. So the triggering date is the date in which the offense is committed. That's under Chapter 4, Section 6.
But we don't have many cases in which we have a definition. I mean, it's almost to say, the legislature says, we define a conviction to mean X, and this person is outside the scope of that definition. The adjudication will certainly occur after.
Right, the adjudication will certainly occur after, but under
Be outside the scope of the definition, so you'd be saying that we're applying the definition as it applied before?
Yes,
As it applied on the date of the offense?
yes, because that, under the rules of statutory construction for penal statutes, which this is, regardless whether it's in the juvenile court or not, the legislature and the public chose to deal with criminal juveniles who violate criminal laws in delinquency proceedings. They created a special part of the juvenile court specifically for delinquency proceedings, and they deal solely with criminal charges.
But why is it not jurisdictional? I mean, they said the juvenile court has the jurisdiction to determine whether a child is a delinquent child. This child, as of a certain date, cannot be a delinquent child.
It's not simply jurisdictional, because I suggest it doesn't just deal with the procedure, it deals with incredible substance, decriminalizing some relatively minor crimes, probably not many, but more importantly, all decriminalizing crimes committed by any juvenile under the age of 12. So there are rights of the parties. The Commonwealth has a vested interest in enforcing its crimes and protecting its citizens. Certainly the victim, the complainant in the Hamden case, has rights that should be determined.
And
so it's
why
not
would-
strict,
and
this is
why
not
would the
just a remedy.
Why would the legislature, who wanted so much to protect these children from being deemed delinquent children, want them to be deemed delinquent children after the effective date?
Well, I would suggest that from the legislative history that we've provided, it's not that the legislature had no intention to eliminate all possibility of delinquent children. There are certain minor criminal behaviors, childish behaviors, that the legislature did not want to haunt children for the rest of their lives. That's why we've got the minimization or the decriminalization of first offense misdemeanors with no more than a 6-month sentence.
We also have
we also
anybody
have-
under 12 who may have committed a serious crime.
That may have committed a very serious crime, and that's a much more substantive and important change to the law.
So why would they, given what we all understand to be the legislative purpose, why would that purpose be effectuated by saying we're going to allow children to continue to be deemed delinquent children as long as their crime occurred before the effective date? Why would that effectuate the legislative intent?
Because I think if you look at the language used by the legislature shall take effect at a particular date. And in one particular amendment that affects the victim, or the Hamden case, was the amendment to Section 54, where it actually eliminates the paragraph.
That's the inconsistency argument. I think the chief is asking about the repugnancy exception.
Well, but what I'm going to say is that amendment, the legislature specifically said, would not go into effect for 1 year.
Right.
So that suggests that the legislature,
Just speaks Gantsy, and he understands me.
sorry.
Knows that I am referring purely to the repugnancy provision. So let's put aside the first part. Let's speak only to the repugnancy part.
Well, okay, well, actually, that was the issue that my brother was going to speak to. But just as far as that particular amendment, what I would suggest how it reflects the legislator's intent. They kicked that out for an entire year, which should signal, or at least it left room for children where complaints had issued, even for children under 12, they could still be brought into court and processed, adjudicated, whatever you call it, on those complaints.
Is that to give them a first offense? So the case you just listened to, which we have no understanding of what first offense means, does this means you could get records of first offenses in that year-long period of anyone in the system? Is that
That wasn't extended that way.
These are felonies.
Right, these go to specifically on the felonies and the arrest of the felons and what the procedure is that has to be followed in order to do the felons. But the misdemeanor is strictly under Section 232, that's 90 days out. And I would suggest under any rule of construction, I suggest that Chapter 4, Section 6 certainly applies. This is clearly penal, and the juvenile has a different mandate as far as disposition, which is perfectly fine, but what makes it penal is because it's the authority of the estate to potentially deprive the liberty of the juvenile. And under statutory construction definitions, that is, in fact, a strictly penal statute.
So the advice to police that you would give would be if the offense occurred before July 11th of 2018 and was committed by a child who was under 12, you can arrest him. But if it's committed after July 12th, you can't arrest him.
Yes, I believe the triggering date is the date of the offense. Yes, if that answers your question, if I
Whether the police can arrest somebody depends upon the date of the offense, not the date of the arrest.
Yes, Your Honor, I would suggest that's true even under common law statutory provisions versus the substantive versus procedural thing. Procedural rules or legislation are not retroactive ad infinitum. There's a certain point where it is, and it's that point at which the amendment applies. And here, the change in the definition is a child between 12 and 18 who commits a crime. It's the present tense suggesting future action, and that too has already passed. The act was committed, and the complaints it also had issued. So I would suggest that under the rules of statutory construction and the language chosen by the legislature, there was absolutely no intent that the amendment be retroactive to these cases.
Can you straighten out our jurisprudence on retroactivity?
I thought I just did.
Okay.
No, no. But I would just say that even if it is procedural, there is a triggering date. It doesn't go all the way back. And the triggering date here is the date on which the offenses were committed, because that is what the amendment is directed towards.
All right, thank you.
Thank you.
Mr. Sheppard-Brick.
May it please the court, David Sheppard-Brick on behalf of the Commonwealth. If I can start by answering Justice Gaziano's earlier question about the retroactive, the provisions that were made expressly prospective. Section 237 makes expressly prospective the new schedules for drugs and also the testimonial privilege for a parent. So in that instance, it needed to be, if they wanted it to be prospective, they had to explicitly state, because it's a rule of evidence, so it otherwise would have applied. In 238, it's the new sentencing scheme, the new mandatory minimums or lack of mandatory minimums, and it applies specifically to a person where the first offense is committed after the effective date. And I think that deals with the, sort of anticipates some of this court's prior jurisprudence about giving the benefit of mandatory minimums to those who have not yet been sentenced. So I think in those two instances, the fact that they said, yes, these have to be expressly prospective doesn't really shed any light on their intent.
That's Galvin and Bradley. Takes into account Galvin, essentially Galvin and Bradley.
Yes. And as to the repugnancy analysis, the question as to why, if they wanted to just end the harm, why make it, why not have it be retroactive? I would say that they were very concerned about making provisions retroactive. There was an extensive debate on the mandatory minimums under the drug laws. One of the senators, Senator Brownsberger, talked about, they were discussing whether or not to make it retroactive to those already serving sentences and to alter those sentences that were imposed. He said one possibility, which is outrageous and which we are not doing, would be to alter the terms of their sentences. We don't want to do that. So I think they were very keyed in to retroactivity, and it clearly made them uncomfortable because once a proceeding has started, and that's the whole idea of Chapter 4, Section 6, that once a proceeding has started, once we've begun, we're really stepping we're stepping over our Article 30 bounds in cutting short proceedings that have already begun.
And did they have testimony from victims before them too? I mean, one thing that makes the legislature cautious is when you have people in the process.
Right.
Any of those, when we go through whatever we've got here, any indication that they had testimony from people who had pending prosecutions before them?
I didn't come across any. There were a lot of different, none in the debates that I saw, but that's certainly.
You've got the Bradley issue, though, on repugnancy, given the disparate impact on minority populations of these convictions. How do you address that?
Well, what I would say to that is that there were a lot of things going on here in terms of what they were trying to accomplish. I think the Bradley problem, and this court also cites Dorsey versus United States in Bradley, when they were discussing the repugnancy issue. And in that case, the purpose of the legislation was to fix a problem that they had created. In Dorsey, it was the 100-to-1 crack to powder cocaine ratio. In Bradley, it was the over-inclusive school zone. This is really the legislature fixing a broader problem, a broader humanitarian issue. And I point to what the court said in Nassar, which is, you would think, given the broad humanitarian purposes of the statute, lessening the impact on juveniles, just as this case does, that the legislature would have gone into, had wanted it to be retroactive. But the court looked at what the legislature did and the procedure, the procedure that they chose, and said, well, no. In that instance, it just because, I mean, if you accept that argument, this is the Didas argument, which is if you accept the argument that this is what the legislature wanted, and they wanted it to give it to the most people, then all criminal justice reform is retroactive, and which is in direct conflict with Chapter 4, Section 6.
But this goes to the definition of retroactive versus prospective. No one is arguing that children previously adjudicated delinquent who were 11 years old will be unadjudicated.
Right.
That would be retroactive. Is this retroactive, what the legislature did, or is, according to your sister, what they did was prospective? That is, with regard prospectively to adjudications of a delinquent child, we will prospectively, as of July 12th, say that prospectively you may no longer find a child to be a delinquent child if he's under 12.
Well, except that would be true without Chapter 4, Section 6 under that argument, because you're right that they do change the definition on that date, but they change that definition for proceedings that have not already been begun. And I think that's the distinction, that the saving statute keeps that definition in effect for proceedings that have already begun.
But you agree that nobody is claiming it is retroactive in the sense of undoing prior adjudications of delinquency?
No, it's not. And I think if they had done that, that would show their intent to have, if they could have done something like that. They could have done something similar to the Section 48 in the 2012, which is saying, look, if you have a prior adjudication, you can come before the court and get it dismissed and vacated. That's not what they did in Section 48, but they could have created a mechanism to expunge these records. The charge in my case is not subject to any of the expungement provisions.
And does that reflect the view that they did not do it retrospectively retroactively with regard to existing adjudications because they wanted something fundamentally different to happen with these children, and that therefore a prospective application, at least with regard to adjudication, makes better sense. That is, we want these children to be handled in a different manner than in the world of delinquent child. We want them to be handled through the social service network.
Well, I don't think that that was, I mean, that doesn't come through in the legislation because they didn't actually provide any sort of alternative means of gaining, you know, I looked at the, you know, the child requiring assistance statute. This juvenile would not qualify for that unless his parents brought him in. There is no mechanism to encourage him actively to partake in state services of any kind, and I'm not sure that he would necessarily qualify for them.
All right, thank you. And we'll take our morning break.